Hearing for the Appeals of the State of Michigan is now in session. The Honorable Mark A. Bouchon, the Honorable Seema G. Patel, presiding the Honorable Chief Judge Michael F. Godola. All persons having business herein draw near, your petition shall be heard. The United States of the United States, State of Michigan, and the court, please be seated.
Good morning. Good morning. Okay. Boy, that was really bad. On behalf of my colleagues, Judges Boonstra and Patel, welcome to the Michigan Court of Appeals. This is panel 5 in Detroit of our February in Lansing. I'm usually in Detroit. We all are usually in Detroit. So apologies. Panel 5 in Lansing of our February 2026 case call. Just a few notes for the lawyers, which many of you have heard from me many times. We have read your briefs. We've had reports from our staff on all the cases that we'll be hearing today. You don't need to belabor the facts, just cut right to the most decisive legal issues and let us know as succinctly as possible why you should prevail in your appeal today. In cases involving minor children or protected persons, please don't use proper names, just stick with initials. As these proceedings are being recorded and will be uploaded to YouTube within the next 24 hours. I think that's all I need to say. So with that, I can call our first case of the day. It's item 1, docket number 375242, People of the State of Michigan versus Dwight Haleakala Kapunii.
Pretty good. That pronunciation there.
Thank you. Thank you.
Good morning, Your Honors. May it please the court, James Fifelski appearing on behalf of Dwight Kapunii, who is the appellee as well as the cross appellant in this case. I know I'll be the only one arguing this, so I'm also happy to take questions since there won't be any rebuttal. This case involves a situation where what started with a 911 call by my client's wife, where she sought medical assistance and made some statements to medical staff in the process of getting medical attention, turned into a situation where, from reviewing the trial record in this particular case, I believe the prosecutor went far beyond the bounds of what is appropriate for a prosecutor who is, first of all, to seek justice and not just a conviction. And unfortunately, I think disregarded the testimony that Mrs. Kapunii provided at trial and created essentially a false narrative for the jury to believe things that were not in evidence that I've highlighted in the brief, to paint a totally different picture than what was actually presented at trial in the evidence. And those included things such as, which I didn't really focus too much on this in the brief, I did in the lower court, referring to someone who never claims to be a victim as a victim. And in this particular case, I counted about 48 different times the prosecutor referred to Mrs. Kapunii as a victim. The jury instruction for domestic violence, which was the charge at trial, refers to complainant, not victim. So even in terms of a well-instructed jury and being consistent with the jury instructions, the prosecutor took it upon herself to refer to Mrs. Kapunii as a victim, even when Mrs. Kapunii had testified that she was not a victim of assault or battery or injury by her husband. And I think that's quite different than a lot of cases where a prosecutor has some leeway when someone is claiming to be a victim, is testifying that they are a victim of a crime, to then refer to that person as a victim. I think that's a different case than if somebody is clearly testifying in open court, I'm not a victim of domestic violence, I'm not a victim of my husband. And Mrs. Kapunii testified clearly, interestingly, in the defendant's case in chief as to what happened on the date in question in 2023, whereas the prosecution saw very little evidence from Mrs. Capuni about the charge at issue, and instead focused its case in the prosecutor's case in chief with Mrs. Capuni on this so-called 2018 incident in California, which is very interesting when I look at this case and the way that the prosecutor set it up. I think two bookends in terms of inappropriate behavior, or we could call it misconduct or prosecutorial error, is the simple fact that the prosecution did not lay down any groundwork for there being an act of domestic violence in 2023 as to the charge at issue from Mrs. Capuni, other than to ask her, I think, if she made a call to the 911 that day. And then the prosecutor goes into these questions about a 2018 incident where Mrs. Capuni very, I think due to lack of memory and the fact that there just wasn't a lot of detail there, couldn't recall much of the information, and the prosecution did not have any other corroborating evidence or even a record of conviction that there was a conviction for domestic violence. And yet, at the tail end of the trial, the prosecutor made one of the key statements that the circuit court on the initial appeal did find to be error when the prosecutor argued that she's been in an abusive relationship for years. So in terms of the issue appealed by the prosecution has to do with the circuit court erring in terms of reversing or vacating the conviction based upon the fact that the circuit court found that statement was clearly arguing facts, not evidence. It was prejudicial, and it had the effect of leading to an improper conviction.
Well,
And-
Mr. Felski, there was evidence in the record that an incident occurred in California in 2018. And it was witnessed by other individuals, and I think it was in a parking lot, who were concerned enough about it that they called the police, right? So it's not that there's it's not that there's a void of evidence of a prior instance of domestic violence, is it?
Well, I think there is limited evidence of the true character or nature of that evidence, because it solely came from Mrs. Capuni in the prosecutor's case in chief. And the questions from the prosecution seemed to provide more substance than the responses did, if you will, insofar as Mrs. Capuni did not recall many details. She did have some recollection, and I think there was mention that the police were called, there was some altercation, there may have been a statement. It wasn't clear from her testimony what the real substance of that was. And I think had the prosecution done more, brought in other evidence or any sort of corroboration, it would have been a different story. But I think the lack of substance in Mrs. Capuni's testimony as to the 2018 incident is where the circuit court really got it correct when it noted the scant evidence produced by the prosecution about a 2018 act of abuse or domestic violence did not lay the groundwork for the prosecution to argue that she's been in an abusive relationship for years. And I would also add to that the fact that when you were talking 2018 to 2023, that's what, 5-6 years, and there was no evidence presented about any other acts of domestic violence or anything else that would have been something of a pattern, which is also why I think the California evidence itself was lacking in terms of its admissibility under 76827B.
Let me go back to the 2018 incident, so we can fill that in a little bit. It's true, isn't it, that defendant in this case was arrested in connection with that incident?
I believe that's true.
Okay, so the police must have found some probable cause of something um, to merit his arrest. And Mrs. Kupuniai told police that, or testified in this case, I think that they got into a quote, physical altercation. And she recalled she had some bruises following the incident. Is any of that incorrect?
I don't think that is incorrect. I'm looking for
Okay.
the testimony that I laid out here. So
We have at least that much in the record of this case with respect to the 2018 incident, right?
I believe that's correct.
Okay.
And
Mr. Pavelski, I appreciate your arguments about the complainant in this case sort of disclaiming that any domestic violence occurred either in 2018 or with respect to this incident. But, you know, criminal cases are captioned in the name of the people of the state of Michigan, not complainants or victims, because the state is vindicating its rights against criminal defendants on behalf of the people. And so I understand that the complainant in this case said what she said following the call to 911 that gave rise to this case. But I think that's an important thing to note. I guess I don't have a question.
okay.
Okay.
I certainly understand the sort of contextual background that prosecutors prosecute in the name of the state. They're not personal attorneys to somebody like Mrs. Kapuniai. However, I think that something like domestic violence, when we read the jury instruction 17.2A, there are more elements than simply that an altercation occurred. And there is a specific intent component to parts of the jury instruction, and that intent and the other side of the intent, which is whether it's consensual in nature. Because I do think under the jury instruction, any sort of mutual, call it mutual combat or mutual aggression towards one another by two people is consensual insofar as they're both in it and neither one is trying to prevent it or stop it or walking away. And now I understand that there's also situations where there may be something like a battered spouse syndrome, which is something we don't have here. There was no expert testimony. There's nothing to speak to a character about this altercation that Mrs. Kapuniai was not aware of because she was so psychologically beat down that she had this battered spouse syndrome. And that's where I think not only did the prosecution not lay any evidence in front of the jury as to the specific intent by Mr. Kapuniai in this so-called altercation to injure or cause a reasonable fear of an immediate battery, but also that it's something that the jury instruction itself says an assault cannot happen by accident. And if this altercation is something where, as Mrs. Kapuniai testified very clearly, she was intoxicated, she was upset, she physically, I believe, slapped or backhanded her husband, she was aggressive, and it then sounds more like a situation where if there is physical contact by Mr. Kapuniai toward her in the context of her testimony, then it was either a situation where he's trying to calm her down, prevent
Aren't those
himself
facts
from being
that
injured.
the jury would weigh, that the jury would give consideration to, as opposed to militating towards a legal determination?
Yes. However, I think where the problem arises in this particular case, and this is why I also think the circuit court didn't quite go far enough in calling out some of the error or the misconduct that the prosecution utilized in obtaining a conviction, because the prosecution recharacterized evidence that was not either the way it was or was not actually in evidence. And then also called on the jury to essentially exercise the civic duty by hold him accountable. You're the only ones that can hold him accountable. Or statements that the victim is clearly terrified. There was no evidence that Mrs. Capuni was terrified. She came into court and freely and voluntarily testified about what actually happened, and not a shred of her testimony indicate that she was terrified. The prosecution did want to rely on the 911 call, which, as I put in my brief, I believe that should not have been admitted because there was no indication of why it was relevant to anything. And if it was a hearsay exception or something just to prove some other reason for why the police investigated, sometimes that happens. But the prosecution relied on this 911 call to then justify its arguments about how it characterized Mrs. Capuni, despite Mrs. Capuni's testimony in court, which was also subject to cross-examination, unlike the 911 call. And so the prosecution pretty consistently took bits and pieces of evidence, some of which I believe should not have been admitted, recharacterized it, and tried to make it suit its own narrative to obtain a conviction, as opposed to let the truth speak for itself. Let the jury decide.
Mr. Fafelsky, you are out of time. Because you're unopposed, you only have 15 minutes. So
It went
anything
by so
else
fast.
you wish to say, just very briefly?
I just would ask the court to uphold the circuit court. I think the circuit court was correct, but also find especially, because if this case is remanded, there will be additional issues, that this 2018 incident is irrelevant and should not have been admitted under 768-27B unless there is a clearer showing that it's relevant and appropriate under the statute. Thank you very much.
Thank you. Appreciate your arguments. The case is submitted.
Thank you.
All right. Yeah. All right. That brings us to item 2. Docket number 368322. People of the State of Michigan versus Lemmy Edward Jones. Ms. McCann, we've granted you 10 minutes of oral argument time.
Thank you, Your Honors. Jacqueline McCann from Stato on behalf of Lemmy Jones. I did raise a few issues related to the convictions, Your Honor, and I'm going to rely on my brief as to those. I want to talk about Boykin this morning because I feel like I see opinions from this court that indicate that the trial bench and perhaps to some extent this court struggles with the application of Boykin. And I wanted to say to this court that this is not one of those sort of edge cases that should give you trouble applying Boykin. This case at sentencing went awry from the very beginning when the prosecutor said to the judge, youth was considered by the legislature, and that's why he can't get mandatory life. And that is all the consideration of youth that he gets. And the judge agreed with him. That is just legally incorrect and error under Boykin. The judge then went on to make additional statements that can assure this court that she didn't understand how Boykin worked and was making legal errors. When trial counsel, defense counsel starts to bring up some of the attributes of youth and is talking about them to the judge. At one point she says, I get it about his childhood and I get that the law is getting better about accounting for people's trauma and so on. And then she says, but that's not a significant factor to me in my sentence. It's about protecting the community. So if you look at what this court.
What's wrong with that? The argument is made. She says, I'll consider that, but you know what? In my mind, that's not the most important thing. So the judge, by his or her own words, has considered it and said it's not as important as other things. And under Boykin, as we know, the judge doesn't have to go through every single thing, jot and tittle, in the sentencing, but has to indicate that, the mitigating characteristics of youth have been considered. And that sounds to me like a consideration of that argument and telling the lawyer, but yeah, I get it. I hear you, but not the most important thing to me.
I would direct this court's attention to your very own unpublished opinion in Boykin on remand,
Mhm.
where similar statements, I would say less egregious statements, were found to be improper. Because it's an indication that the judge is acknowledging that youth exists, but an indication that the judge is not applying it as mitigation. And it has to be applied as mitigation to each factor. So I would direct this court to the unpublished opinion of Boykin on remand, where the court found error and remanded for resentencing. And then more recently, in People versus Mark Abatoy, a series of unpublished opinions. This court just issued Abatoy 3 on January 20th. Again, finding a Boykin error and remanding for resentencing to similar, and I would say less egregious, statements by the judge, where you don't have that initial whole disavowal of, youth doesn't matter once you don't get life. But where the judge acknowledges youth, but isn't using it in a mitigating way for each individual snow factor. And I think that's what occurred here. And I would ask the court to be consistent, even though they're unpublished opinions, they're available to all of us, and it doesn't help the body of case law if we're having judges say similar things, and sometimes it gets sent back for resentencing and sometimes it doesn't.
Ms. McCann, I have a question,
Yeah.
and this might not be just specific to this case and a little more philosophical, but what should we expect from the trial court judge? Because I was reading through the transcript on this one, and I feel like she took her responsibility very seriously, was going through each of the factors and doing what she's tasked with in terms of weighing the factors and determining a sentence. And I think that there's language in there that if we're looking at it, giving all deference to the trial court judge shows that she's weighing the mitigating factor of youth, but then using other, balancing it with other factors that she found more relevant. So what is the trial court supposed to say? What are the magic words?
Well, to some extent, I feel for trial judges because Boykin actually says you don't have to say anything. You almost get in more
Right.
trouble the more you say. So I get that.
I have to give reasons, but yeah, go ahead. I'm sorry.
But I wanted to, taking your example, Your Honor, of she's sort of taking things conscientiously and she's making statements and she's telling us how she weighs it. I just want to take you to the bottom of page 28 of my brief. And again, I'm just going to read, I apologize, I'm going to read the 2 or 3 sentences. I also read about the chaotic childhood, and I acknowledge as well the criminal justice system is getting better and better at understanding trauma and the kind of childhood that you described in the sentencing memorandum. But I think that's of little comfort to a mother screaming in pain today, or to the next mother or father or sister or brother or aunt, uncle who is worried about their child out innocently riding around in a car and having a bullet ripped through their head. So I acknowledge the issue that you raise, but it is not of a significant factor in my sentence, but because ultimately it's about the safety of the community. I would say to you that that's saying that the general reaction to the community to homicide, every family that unfortunately has a person they love killed in a homicide has that reaction, and that
Yeah, but not every homicide case is the same.
that's true, Your
You know,
Honor.
I mean, this was really
This was a drive.
egregious
I would
behavior.
say
Egregious.
this is a drive-by shooting, Your Honor.
It
And
was,
a
okay,
carload
that's
of
one way to
kids.
characterize it.
But what are the attributes of youth, and why do
I
we
wouldn't
say,
characterize it that way.
why do they say that youth lessens? Because again, you're affected by your peers. He's in a car with
Well, this is
3
an
other
argument that
people.
youth always has to lessen the sentence, and that's not the law.
It doesn't always have to lessen the sentence,
Right.
but you have to explain why. And I submit to you that
Boykin
they,
says you don't.
well, when you
Right? I mean,
do,
what am I supposed to
but
do
when
with
you do,
Boykin?
we get to criticize it. And I would say from the start, the attitude was he didn't get life, so we start at 40, and somehow he has to show how it goes less.
Going back to that, the few sentences that you just read, because that was also what I was focusing on in my analysis. I feel like those sentences showed that the trial court looked at youth, considered it as a mitigating factor, but then looked at these other circumstances surrounding the crime and flowed from there.
Well, let me say what I think, I don't want to give this away in case you remand for rearticulation, but say the judge, instead of saying, here's this attribute of youth where he suffered this bad childhood, and that goes to the fact that he might be able to be rehabilitated because he couldn't take himself out of that situation. But all of us are afraid of our children being killed by their friends over some petty grievance. And I need to protect our children from this. That's generalities. If she had said something like, his childhood shows me that he can't be rehabilitated because of X, Y, or Z, or this case is particularly egregious. It's not just that he was influenced by his peers. He was plotting this for 2 years or whatever, but not just the generality of we all want our kids to be protected from harm.
Is that what you're advocating? That we take Boykin a step further and say, okay, that a trial court does have a responsibility to put these elements on the record, and this is how detailed factually the court has to go into that? Because the struggle that I'm having is sitting as an appellate court judge, fly specking a trial court's analysis. And I looked at the record, I looked at what the judge did in this case, and I feel like she took her responsibility very seriously, went through each factor. And if I'm going to say this wasn't enough, that I need to remand this for you to do it again, I feel like I don't want to disrespect a trial court and her role and the space that she has, and I want to respect my role in terms of what my responsibility as a reviewing judge. And I think that we're hitting a space where Boykin says one thing, and you're asking us to remand for something else. So are we in? Is this a? Are we taking Boykin a step further? Is that what you would like?
Well, a couple responses to that, Judge, or Your Honor. First, I would say this case is in a different class than even Boykin on remand and Abatoy, because here we have that initial youth doesn't matter anymore. I agree with you, prosecutor. So that takes it to another level. But setting that aside for a bit, we asked this court for consistency. Am I asking you to do something that Boykin says you don't have to do? I'm asking you to follow the opinions of your colleagues that indicate when they do go further and say these types of things in Boykin on remand and Abatoy and Black, that you apply that consistently. And if you don't want to, that you ask for some sort of conflict opinion or tell the Supreme Court what it is they need to further explain to this court so we can have a consistent application here, and that the trial court judges can know what they're supposed to do.
So much I could say.
Yes.
I know. But because of the case law that exists in present day, under this court's case law, again, nothing here was what occurred here in my mind is more egregious than in Boykin on remand, more egregious than in Abatoy, because we have that additional beginning of the proceeding where, he didn't get life, youth doesn't matter anymore. And so I'd ask the court, you don't even need to get to the proportionality, because that's just legal error that was made at the beginning and set the whole tone.
I just want to note too, and you are at the end of your time. I'll give you a couple minutes for rebuttal though,
Thank you.
because we asked a fair number of questions, but I did refresh my memory with respect to who the judge was. She's no longer serving, but one of the finest circuit court judges in this county for the time that she did serve, very highly regarded. I know that even the best judges can make mistakes. I don't know that I'm all that good, but I've sure made some along the way. But I have to second what Judge Patel said about how carefully she handled this sentencing, and the trial.
I tell attorneys the same thing when we raise IAC. I'm not saying you're not a good attorney. It's about an individual instance.
All right, thank you.
Good morning. May it please the court, Elizabeth Allen from the Ingham County Prosecutor's Office on behalf of the plaintiff appellee. And I'll make my arguments short. I've heard the panel's comments. Only that because Judge Patel, you mentioned what is it that the trial court has to do? And what Boykin tells us is that the trial court has to make a record sufficient for appellate review, and that the trial judge does not have to go into a detailed on the record of all the specific factors or how it applied the mitigating factor of youth to the snow factors. And so here, Judge Dragonchuk did make a record sufficient for appellate review. And not just once, but twice. We had another hearing before her where the same issue was raised, and she said, I did consider youth as a mitigating factor. I did at sentencing. I'm reiterating right now that I did. But I also considered all the other factors, and my decision has not changed. So unless the panel has any other questions, I'll leave it with that and ask you to affirm the convictions and sentence.
I'll, at the risk of prolonging this, anything to say about the unpublished cases that Ms. McCann cited to and how they compare to this case, Boykin, Apatoy, the rest?
Yes, Judge Godola, I did mention People versus Boykin, the unpublished case, in my brief as well, because in People versus Boykin on remand, the trial court considered whether the defendant's age was a mitigating factor, and it did not consider it as one. Whereas here, the trial court did not say, and I mean, we can cherry pick a couple sentences, but when she mentions to the prosecutor, you're right, the legislature has considered youth. They have created a system now. You know, we're within that, and which is why the defendant received the legislative sentence.
That's just a statement of fact, I think.
Exactly. That's
all that was in context.
And that's my take as well, because she said so many more things after that. And so she did not sit here and deny that youth is a mitigating factor or consider whether it should be one. She said it is. I'm considering it, and I'm also considering all the other factors. So I think if we look at Boykin on remand specifically, which was mentioned in the brief, and the other cases have come out since, the trial courts are debating whether or not it is a mitigating factor and whether it should consider it as one. That is not what the trial court did here. She followed exactly what she was supposed to do, and she actually did go on the record with more explanation as to her sentence than was even required. She made the record sufficient for appellate review, and so that is what we're here to look at, and we would ask the court to affirm. Thank you.
Ms. McCann, I'll give you a minute or two.
I also highlighted quotes from Boykin on remand and other things in the
Yes.
brief in black. And I guess I'll just close by saying like, I really think they need to take another case to explain how Boykin is supposed to work
I wouldn't
in
disagree with that
process.
necessarily.
And if the court can say anything in its opinion that would indicate that, I still think we should win. But if the court would indicate that we need some clarification.
All right. Thank you
Thank you.
very much. Well argued on both sides. We appreciate your arguments, and the case is submitted. All right, that brings us to item 3, docket number 369428, People of the State of Michigan versus Nicholas Gunnar Gage. And Mr. Simon, I believe, is arguing remotely. Okay, there we are. Mr. Simon, I think we're ready for you to give us your appearance and present your argument.
And may it please the court, Jonathan Simon on behalf of Mr. Gage. I'd like to start with the first argument. It involves the discovery violation. Well, I'm going to use violation in quotation marks. I'm not suggesting that there was any wrongness but by the prosecutor's office, but the defense was only made aware of 50 photographs and the strangulation evaluation, I think literally a day before trial. Now, I have cited a number of cases, and Ms. Allen makes the point at the bottom of page 14, top of page 15 of my brief, that because some of those cases may have been decided prior to November 1st, 1990, they are of no precedential value. And I would like to make this panel and Ms. Allen aware of a very recent case, published opinion by a different panel of this court. It was released on January 20th, 2026, and that would be Plachta versus Plachta, Placachta, uh, and it's docket number 374260. It is a child custody case. However, in that published opinion, they did address in part the binding effect of published Court of Appeals opinions that were released prior to November 1st, 1990. And in that opinion, that panel of this court clarified that those opinions are in fact binding precedent and are not to be treated as unpublished opinions. They go on to say that the difference between pre and post 1990 opinions is that a panel can overrule a pre 1990 opinion without convening a conflict panel. So I believe that the cases I have cited, they are published opinions, and even the ones that are decided prior to November 1st, 1990 are precedential. And we urge the court to adopt the arguments which I have made, which include those cases. Now, this particular discovery issue, there was a request to strike the report, to strike the photos, and that was denied. The remedy here was to allow counsel, require the witness to testify at the close of the prosecutor's proofs, which was a couple days later. And so this supposedly would give the defense counsel time to prepare. But I don't know that you can say that the remedy achieved the objective, which was suggested, because I don't really know how, while you're in the course of a trial, you have time to research, you have time to consult with experts, you have perhaps time to amend your witness list, add an expert to represent testimony to suggest that the testimony that was presented by Ms. Rosen was somehow flawed. And we also believe that the testimony should not have been allowed, even if counsel was aware of it in a timely fashion, because really all it did was just vouch for the credibility of the complainant. It gives reasons for her actions. And to my mind, that only enhances the prosecutor's case by vouching for witness credibility and explaining away the inconsistencies in her testimony and in her police reports. And so we believe that not only was counsel surprised and not given an adequate opportunity to address the issue, but also that the evidence itself was inappropriate and should never have been presented anyway. Moving on from there, I don't believe in argument two that there was a sufficient showing of due diligence to justify the lack of a missing witness instruction. We believe that the court should have instructed the jury that that testimony of that res gestae witness would not have been helpful to the prosecutor, or in fact would have helped the defense. That was a person who was present, and that was a person who had information, firsthand knowledge of the facts and events, and should have been known to the jury that that testimony would have been helpful to the defense. But I'm going to move on to the two sentencing issues, because I think that they also have considerable merit. And the first one, argument three, involves the statement of the complainant in the pre-sentence report. Now, in there, she makes the comments that Mr. Gage is violent, that he should not be allowed out on the streets, that he abuses drugs, he abuses alcohol. And counsel objected, and the court said, well, it's her statement. Well, the fact that she made the statement doesn't make it true. The fact that she made the statement doesn't make it something which should be brought to the attention of the Department of Corrections and the parole board. This pre-sentence report follows Mr. Gage throughout his tenure with the Department of Corrections. It's relied upon for purposes of deciding where he should be placed, what security level he should receive, what privileges he should be allowed, when he should be paroled, and to suggest that he's violent, that he should never be allowed on the streets, that he abuses alcohol, that he abuses drugs, I think is not part of what should be part of a victim's witness statement. I want to tell you, short story. I was in trial last week, and there was an attempt to bring in a statement of the complainant. My objection was it's hearsay, and the judge says, no, it's his statement. Well, the fact that it is his statement did not reduce it anymore. It is still hearsay. It's still an out-of-court assertion. It's still not under oath. It's still not subject to cross-examination. It's still used to prove the truth of the matter asserted. And so it was hearsay, and it did come in, even though I think it should not have. The fact that this complainant made this statement and the fact that victim impact statements are allowed doesn't mean the victim can make statements which have no bearing on this case, which have have incredible prejudicial effect when viewed by the Department of Corrections, when viewed by the parole board. It's going to cause probably him to remain as a level 4 for an extended period of time. Probably it'll cause the parole board to feel that perhaps he should not be eligible for parole anytime soon after his early release date. And it is, I think, it's unproven. It's not something that should be part of that report, and we urge the court to send this case back with instructions to strike those comments. The final argument would be the assessment of offense variable 7, excessive brutality. Now, certainly there was testimony that he grabbed complainant by her hair, dragged her down the stairs. But it's also true that he was charged with assault with intent to do great bodily harm and domestic violence. Now, under People versus McGraw, the variables should be gauged based upon the offense. And this is part of perhaps a different crime. He was convicted of great bodily harm. He was convicted of domestic violence. Grabbing one's hair, dragging her down the stairs may be part of both of those crimes, but it was not part of the CSC. It should not have been assessed. And those 50 points did make a difference because it increased his guideline range from 130 to 225 months up to 171 to 285 months. And now the definition of excessive brutality is savagery or cruelty beyond everything, even the usual brutality of a crime. And certainly those words may be used in terms of the entire transaction, but I don't believe that they apply specifically to the CSC. And for that reason, we believe that they should not have been assessed. And so we're also asking that Mr. Gage case be remanded for resentencing.
All right. Thank you. Any questions for Mr. Simon? All right. You'll have time for rebuttal. Ms. Allen.
Good morning. May it please the court again, Elizabeth Allen, Ingham County Prosecutor's Office on behalf of the plaintiff appellee. And I'll be brief to hit the points that were raised by opposing counsel, and beginning with the discovery violation or the remedy for the alleged discovery violation. As this court knows, what the trial court is looking at in that situation is to balance the interests of the courts, the public, and the parties in light of all the relevant circumstances, including the reasons for noncompliance, and a showing by the objecting party of actual prejudice. And in this case, the prosecutor said, I just learned the day before trial that there are photographs from the SANE exam and there's a strangulation assessment. And I turned it over to defense counsel as soon as I got it. And defense counsel, part of their argument for it not coming in is saying, well, it's cumulative because the photographs are already, the victim already had those injuries when the police interviewed her. We already have those bruises and everything. And also it's cumulative because the strangulation is something that the nurse could testify to even if we don't have her report. If the same nurse comes in, she can testify about her strangulation assessment. We don't need the actual form. And so the trial court said, look, we'll let 11 of the photos. There was 50 total. They'll let 11 in, and we're going to give you till Monday, which is 3 days to go through and see if it's going to affect your strategy, and we'll let it come in then. And so when the trial court is in the middle of a trial and assessing all the circumstances of noncompliance, again, a showing by the objecting party of actual prejudice. The objection was not that he was actually prejudiced, just that the prosecutor didn't need this evidence. So this was a reasonable way to make it more fair and to let trial counsel get a look at the photographs that were going to be admitted and the assessment and let it come in days later. Because as trial counsel noted, that witness was going to testify anyways, and she could have testified to her assessment. So the actual form itself that was being objected to was not a showing of actual prejudice by trial counsel. And then moving to quickly as to the missing witness, in this case, obviously the law is that the prosecutor has to attempt to do everything reasonable, not everything possible to obtain the presence of a witness. And the record here is replete with all the different things that they did. They issued a subpoena. They sent a detective to his address. They located a phone number, called it, talked to the witness's father, who says, yeah, he lives here, but he's not going to come to court because he has warrants. The prosecutor said, oh, if he has warrants, we can send the fugitive team. Let's see if he has warrants. He didn't. So they go back again and they knock. No one's answering. The detective calls the witness's dad again and says, do we have a better address? Do we have another place we could go? And he said, no, I'll let him know that you're looking for him. And the detective searched the jails and the hospitals. And so although I think opposing counsel said there's a couple other places they could have looked, this was reasonable. They tried to find this witness and he was not able to be found. And so the trial court did not abuse its discretion in not giving that specific instruction. And as to sentencing, the victim impact statement, first the aspect that she said he's violent and abuses alcohol, that was in the record. He has 3 domestic violence convictions, and he was just convicted of criminal sexual conduct in the first degree and assault by strangulation. And moreover, she testified that they were all abusing alcohol the night this happened. There was whiskey in the house and they were drinking, which led to this exact situation. So to say that wasn't supported, it was exactly her experience. And so to say that in her victim impact statement was well allowed.
What about the statement that's in the PSIR about other women?
Yeah, and when I looked at that, our position is when she's there and she's talking about how this has affected her, she doesn't say those other women were truthful or that it did happen. She said, as a result of this and going through this trial and everyone knowing about this, other women are reaching out to me and giving me the trauma they've experienced or telling me that they've also experienced something at the hands of this man. And the trial court said, in part, the trial court said, this is her statement, but he said that wasn't part of the record. So when he's talking about what the trial court is considering as evidence, I think it's pretty clear he was saying this is not part of the record for me to consider, but also it's the victim's experience. She's not saying he did abuse these women or that he has assaulted or sexually assaulted other women, just that now she's receiving that trauma from other people and they're reaching out and saying, I have also been abused. So it's our position that that does not require a remand for resentencing or to remove it because that was her experience as a result of this crime at the hands of the defendant. And finally, I'll just move to, unless there's more questions on that aspect. No. Okay. For offense variable 7, when we're looking at whether or not he was trying to increase, the fear, I believe, I want to make sure I have the exact words for OV7, egregious conduct designed to substantially increase the fear and anxiety a victim suffered during the offense. He dragged her by the hair to the basement to commit the offense of CSC 1. It wasn't as part of the strangulation, and it was part of his way to remove her and scare her and bring her to the basement. And I don't want to go through all the facts in the sense that, just to say how brutal it was, but it wasn't just that. She testified she could feel her head bouncing off the concrete stairs. He brings her to the basement and jams her up against a wall where he continues to beat and strangle her and bring 2 other men down there to put on a show and say, this is how she likes it. So this was not part of just another crime that can't be considered. It was designed to remove her to a separate part of the home, substantially increasing her fear and anxiety, and excessively brutal to commit this crime against her. So unless there's any other questions, we'd ask the court to affirm the sentence and the convictions.
Any other questions? No.
Thank you.
Mr. Simon, any brief rebuttal?
Nothing further.
Okay, thank you. Appreciate your arguments, both of you. Well argued. The case is submitted. Mr. Simon, you're a busy man this morning. You can stay right there. I'll call the next case, which is item 4, docket number 371629, People of the State of Michigan versus Julian Guadalupe Revilla.
Good morning again, and may it please the court, Jonathan Simon on behalf of Mr. Revilla. This was a first-degree murder case. The issue is the statement made by Mr. Revilla prior to the polygraph examination. Now, there was an objection and it was overruled. There was an appeal to this court. Leave was denied. There was an application to the Michigan Supreme Court. Leave was denied. However, the denial of leave is not a decision on the merits, and it is not the law of the case. And so the matter is still before this court for a determination on the merits as to whether those statements were should have been suppressed. Now, there was a couple of issues involved in the motion. Certainly, I think counsel argued in his motion and before this court, well, in the applications, that because of his alienage, there was, I guess, a lack of understanding or appreciation of Miranda rights. There's also but there's also issues involving the promise of leniency. And we believe that also there's a claim that he was not in custody, and so there did not even need to be Miranda warnings. This is a situation where the vehicle was located and Mr. Ravella was located in the state of Ohio after the vehicle had been involved in a collision. And Mr. Ravella was in an Ohio jail based upon the collision itself in Ohio. And that is where the special agent went to take the polygraph examination. And the people make the argument that, well, because he's there for the Ohio case, but he's not in custody because of the Michigan case, he is not in custody. And I don't think that's an accurate statement of the law. I believe that he's in custody. He's being held in a detention facility. His movement is restricted. He's there because he is charged with a crime. And he is in custody, even if it is for a different matter. And so I believe that Miranda was required. And so further, I believe that the statements of the special agent indicating that notwithstanding the Miranda warning that anything you say can be used against you, I think he was given the impression that it would not be used against him. And I think that was one or more of the bases for his statement. We believe that it was involuntary, it was coerced or based upon promises of leniency. And for that reason, it should have been suppressed. We ask the court to so rule and remand for a new trial without the use of that statement.
All right, any questions for Mr. Simon? All right, seeing none, counsel?
Good morning, Your Honors. May it please the court, Christopher Candela appearing on behalf of the Eaton County Prosecutor's Office. I guess I'll start with the fact that the invocation or the invocation of the right to counsel is unpreserved in this case. It should be reviewed for plain error because what was raised previously in the trial court in the prior appeal was an attempt to suppress his statements based on his level of education and the promise of leniency, not the invocation of the right to counsel. That issue was not previously raised. Therefore, it should be reviewed for plain error only. But the reality is, in this case, the defendant was not in custody under binding case law that we have, Howes or Howies versus Fields. Imprisonment alone doesn't constitute custody, and at least not for the purposes of Miranda. And the facts in this case further support that. He's lodged in the Preble County Jail on completely unrelated offenses. The case here hadn't been issued yet. There wasn't a warrant for his arrest yet. They were investigating the Susie's murder. During that interview, he's unrestrained. Food and drink are provided to him. He explicitly states that he knows he can terminate this conversation and walk out of this room. He says, I can straight walk back to my cell. He's aware that he can leave this room. So I think the record's pretty clear that he's not in custody. His invocation, the claimed invocation of his right to counsel, it was equivocal. And two, the argument is taken out of context. It's kind of a cherry picked quote here. The defendant in that situation, they're having a conversation about a armed robbery that happened prior to the murder. And the reason they're discussing that is because the firearm that was used in that robbery is the same firearm that was used in the murder. When he makes the statement that he might want to talk to an attorney, what he's referring to, he says that when they start asking him about, well, what are the names of these other people that were involved in this armed robbery? Well, then he says, wait a minute, he doesn't want to throw his friends under the bus. But he then follows that up with, I'm good with continuing to talk about Susie. And the detectives clarify numerous times after that. They take a break, they go get lunch. They ask him several times, are you good with continuing to talk to us about Susie and this murder? And he says yes several times. The voluntariness and promise of leniency issue, looking at People versus Conti, the inquiry is whether there was a promise of leniency, and whether that would be reasonably understood as a promise of leniency, and whether there was reliance on that. I argue in my brief that it's not a promise of leniency, it wouldn't be reasonably understood. But even if it is, even if this court was to consider it as a promise of leniency, there's no reliance on it. Julian continues to deny his involvement in the murder for a significant period of time after the statements made. And the context of that statement is, in the pre-polygraph section where they're determining what questions they're going to ask him for the polygraph test. And they're telling him, if you want to pass this, you have to tell us the truth. But we get to that post-polygraph interview, and he continues to lie. He continues to blame it on 8-Ball.
Then the polygraph examiner, I think, says, so you have to tell the truth. And if you change your story from what you told before, they can't use that against you, meaning the inconsistency between
Correct.
the statements previously made and something he might say that's inconsistent with that during the exam.
That's
right?
correct. Yes.
And it's hours later that he confesses.
It's hours later that he confesses. He continues to blame 8-Ball for this murder for I think it was 2 hours. And not only that, but between the statement, the challenge statement and his confession, Detective Baez tells him, I can't make you any promises. He explicitly says that to him. So, there's a clear bifurcation there. He's clearly advised that there's not any promises of leniency here. Unless the court has other questions, I'll rely on my brief.
Questions? All right, I don't have any. Mr. Simon?
Yes, just one comment, and that is that even if the court believes that the right to counsel sub-argument is unpreserved and subject to plain error review, it is clear that the issue of the claim of a promise of leniency was preserved and should be reviewed by this court de novo.
Okay, very good. Anything for Mr. Simon? All right. Thank you very much. Appreciate your arguments. That case is submitted. Mr. Simon, again, stay right where you are. Item 5, docket number 371525, People of the State of Michigan versus Brankel, Seaman, Anthony Bates.
Good morning for the last time this morning.
Right.
Jonathan Simon on behalf of Mr. Bates. Mr. Bates was convicted of first-degree criminal sexual conduct on the claim of personal injury. And we don't believe that that there was sufficient evidence of that. And we believe that at best, the people were able to prove third-degree criminal sexual conduct, force or coercion, but without the aggravating circumstance. So basically, we think that the conviction defies the proofs which were presented at trial. This court should find that there was at most a third degree, which would significantly reduce his exposure in this matter and also entitle him to a resentencing. We also take issue with the saying the expert witness, and I always see these in CSC cases. I'm here to present evidence about the dynamics, and without knowing anything about the case and without knowing anything about the complainant, which is admitted up front. I mean, there's no claim of any inside information. She's there to present what she believes is the dynamics of the situation, to explain away the complainant's actions or lack of actions. And in that respect, we believe that all she's really there to do is to vouch for the complainant. And so I think that that's grossly unfair to present a witness just to say, yeah, everything that she did makes sense. Everything that she did is consistent with what other people would do. Everything that she did.
That wasn't the testimony though, was it? Because she didn't even know, the expert didn't know what the complainant had said or not said. She just testified generally with respect.
That's correct. In response to questions by the prosecutor who had intimate knowledge, well, knowledge of the events and geared the examination toward those things that he knew would be, I guess, issues for the jury to scratch their head about. And so putting somebody out there and asking them these questions to try to suggest that everything that you've heard previously from the complainant makes sense. And we believe that there's really no basis for that testimony because all it does
You're
is
kind of
vouch.
putting the prosecutor in a catch-22 because, you know, we now have established, I think, well established and that experts can't testify that the victim's telling the truth or that this happened, there was, you know, a sexual assault or domestic violence, whatever it is, that's impermissible. So I think in this case, what it suggests to me is the prosecutor is taking pains to avoid that and kept the expert ignorant of the facts of the case. So aren't you putting the prosecutor in kind of a no-win situation with this argument?
I think it's an end run around that rule because even though the witness would not be able to say, yes, I believe her, she's saying she's giving evidence for to give the jury reason to believe her. And it's basically doing the same thing in a different fashion.
Okay.
There's also issues about the flight instruction. We don't believe that there was sufficient reason to tell the jury that, and I understand it says that it could be for other reasons, but it also puts in their mind consciousness of guilt. Well, he left the state of Michigan, therefore he must think he's guilty. And also we believe that the court did not provide sufficient reason for what has been called harsh medicine involving the consecutive sentencings. Certainly, the statute allows consecutive sentencings of 2 acts of CSC occurring out of the same transaction or occurrence, but there must be a better reason than the reasons given by the court. We submit that there were none, and there is no basis for consecutive sentencing. And this court should either remand with instructions to sentence concurrently or to allow at least the court to provide a better reason for doing it in a consecutive fashion.
Any questions for Mr. Sun? Okay. Mr. Scrotenbor.
May it please the court, Jerry Scrotenbor, Ingham County Assistant Prosecutor for Plaintiff Appellee. Well, the question about the expert witness. In the first place, unless I'm wrong, defendant did not even raise the issue he's complaining about right now in his brief. In the second place, there was no objection, so it's plain error at the most. And in the third place, Muniz from 2020, this court said that this testimony is admissible, period. Moving on, the flight instruction and consecutive sentence, I'm just relying on my brief on those. There was no error. There is nothing here that requires any relief. I ask the court to affirm.
Any questions for Mr. Scrotenbor? Okay, thank you. Any brief rebuttal, Mr. Simon?
I'm just checking. Yeah, I did file a, I think a motion to remand, if I'm not mistaken. And so as to Holly Rosen's testimony, I would submit that the issue is preserved.
Okay, very good. Thank you. Appreciate your arguments. That case is submitted.
Thank you.
And thank you, Mr. Simon. You are done for the day. It's just past 11. We're not at the end of our 10 a.m. call as yet, but I'd like to take a brief 5-minute recess at this point, and we'll come back for item 7.
Brian? Honorable Court of Appeals State Commission now in session. Please be seated.
Okay. As previously indicated, we'll resume with item 7, docket number 375-595, People of the State of Michigan versus Archie Sova.
Good morning. May it please the court. Jonathan Foreman with the Ingham County Office of the Public Defender. I'm representing defendant appellant Archie Sova in this matter, requesting that this court reverse the order of the lower court, determine that the extension of the stop here to call for the drug dog violated my client's Fourth Amendment rights. I'm going to focus on 3 primary points in my argument. First is that there was a seizure here. Mr. Sova was approached in a parking lot with defective equipment, and he was required to provide the identification. He was ordered to remain out of his vehicle. And I think most importantly, he had his movements compelled by the deputy on scene. He was told, I'm going to have you talk to my partner here. At that point, it would have been clear to him that he was not free to leave, because the deputy said to him, you need to go here with my partner on scene. So it would have been clear to him at that point he was not free to leave. And all of this occurred before the call for the drug dog. So at the time that the drug dog was called, I think my client was clearly seized. All those factors make this case much closer to Freeman, and I think actually beyond Freeman, as opposed to Schenkel, which is what the prosecutor relies on. The Schenkel court distinguished Freeman specifically by noting that the defendant in Schenkel was never ordered from his car. To put it another way, his movements were never compelled by the officer. But here, as I noted, my client's movements were compelled because not only was he ordered not to go back into his vehicle, but he was ordered to speak to another person on scene. It would have been free to him. He was not free. It would have been, clear to him that he was not free to leave. Second, the call for a drug dog was an extension of the stop. There's no, this is a mid-stop extension of a mid-seizure extension of the stop. I know that there's no case directly on point in Michigan, but I think kind of the coalescing of the case law across the country makes it clear that the interpretation of Rodriguez is that mid-stop extensions also count against the government, and that ruling makes sense. Those rulings make sense.
How long did it take for the dog to get there? Can you refresh my?
I think it was around 15 minutes.
Okay.
It was around 15 minutes, but the call for the drug dog, which was in the middle of the stop, it was a short amount of time. Admittedly, it was about 20 seconds.
Yeah.
But that's where I think, and I think it's supported by case law across the country, is where the violation occurred, was when he called for the drug dog, detouring from the purpose of the initial seizure.
Which we did very early on in the back and forth with the defendant, right?
That's accurate. So I think, I cite the Idaho Supreme Court case State v. Karst, which is really similar facts to this case. It was a 19-second extension of a stop there to call for a drug dog. And the Idaho Supreme Court said that's enough. And I think to violate the Fourth Amendment, if there's no independent reasonable suspicion, I think that ruling makes sense, because if we're drawing lines, we're saying that there's a permissible amount of time to violate the Fourth Amendment, to keep someone unreasonably seized. And that can't be the rule. The rule has to be there's no permissible amount of time that an officer can violate the Fourth Amendment to unreasonably seize somebody. The circuit, I think, has laid out a really helpful test that I think this court should adopt. That case is U.S. v. Whitley. It was a Judge Gilman opinion. I think it was Judge Moore and Judge Sutton also on that panel. And in that case, the court determined that the relevant question to ask is whether the stopped party can show either that the police activity was not tied to the traffic infraction or the reason for the seizure, or that the traffic stop reasonably should have already been completed. I'm not arguing the second one here. I'm arguing that that the police activity here was not tied to the traffic infraction. By calling for the drug dog, the officer clearly did something that was not tied to the initial purpose of the stop, or sorry, of the seizure, which was to investigate that
It's
defective
just
equipment.
investigatory at the outset, right? I mean, the car was in a Walgreens parking lot at about 5 in the morning or something, and the defendant was outside the vehicle, and the officer sees this and goes
Correct.
into the parking lot and starts asking questions, right?
Correct. So yes, and I think that's an important distinction to draw. It was investigatory. This isn't a traditional traffic stop in that there was no traffic
Yeah.
infraction.
Right.
But I think, so I'll acknowledge and I'll concede that when the officer walked up to the car, not a Fourth Amendment seizure at that point. It's only when the future steps occurred, the request for identification with the compliance with that request, the requirement that the order that he not go back into his vehicle, and the specific, and especially the compelled movements. I'm going to have you go over here and talk to my partner here. But as, so that's the Whitley test that I just discussed. I think almost every federal circuit, I have about 2 pages worth of cites in my brief, where almost every federal circuit has followed suit. And as I said, not addressed yet here in Michigan, but I would ask that this court adopts that precedent from across the country.
So what does the officer need to have to support the summoning of the drug dog?
That's my third point. He needs to have reasonable suspicion.
Correct.
And here, I think that the finding of the trial court that there was reasonable suspicion was clear error. I think that the finding of facts was clear error, and certainly the application to the law, which this court reviews de novo, was an error. The police report and the deputy's unequivocal testimony that was gleaned through the adversarial process makes clear that he called for the drug dog only because of his knowledge of my client's supposed history with drugs, with dangerous drugs. And as this court has determined before, albeit it was an unpublished case, but it relied on a bunch of federal circuits to support it, a person's criminal history alone can't create reasonable suspicion for current criminal activity.
The officer says, well, he possessed drugs in the past, and I know this, so there's a good chance he possesses them right now.
Exactly. And if that's the rationale, that means a person's past drug conviction waives his Fourth Amendment rights for the rest of time.
Right.
And that can't be the rule.
Right.
So
it would be as if, would it not? Let's say the defendant had been pulled over and convicted of a DUI once or twice or 3 times in the past. The officer who arrested him or cited him for those infractions pulls him over a 4th time and says, get out of the car and we're going to do a breathalyzer right now.
exactly. It would be exactly like that. I've actually won in the Ingham Circuit Court on that exact issue, Judge.
Yeah.
So it didn't make it up to you. But it would be exactly like that.
Yeah.
So the people offer one rationale for the extension, which I don't think really lines up. They offer that my client was supposedly reaching into his vehicle and that created officer safety concerns. But the officer specifically testified that those safety concerns were about weapons. And
that's the fact that makes the case a little more challenging for you, I think. The fact
Understood.
that he's rummaging around in the front seat of the car and the officer has to tell him more than once to stop doing that. So would it not have been reasonable to assume, and I think he could take into account the fact that this individual had a history of possession of dangerous drugs, and link that up with the fact he's doing something in the front seat. Maybe that's an effort to conceal something. Or, as he testified, not to conceal, but to extract something from the vehicle, namely a weapon, right?
Right. If the officer had articulated his rationale differently.
He never said what I posited, did he?
Correct. What he specifically testified to at the motion hearing was that he was concerned about weapons by my client reaching back into the car. And I'm not sure that respectfully, I'm not sure that the video supports a rummaging. I think it was a couple, he might have gone for a half a second, but it's not, it wasn't like he was shuffling things around or anything like that when he moved back into the car, at least based on my memory of the video.
Okay.
But precisely, I think the point you raised is exactly right, that the officer who is responsible for articulating what led to his findings of reasonable suspicion said, I was concerned about weapons. And what the people are arguing is that his concern for weapons allowed him to call for a drug dog, which doesn't make sense. It doesn't line up in my view. The trial court had two other rationales that the people don't even bother to defend. So I don't know if I need to spend too much time on that. But the condition of the vehicle was the initial reason for the seizure. So it also can't be a reason for the extension of the seizure. And his nervousness, I don't think is supported at all by the video. I think it's by what we can see through that. But regardless, courts have said a lot of times that nervousness and condition of the vehicles aren't suspicious. It's just the way a normal person might react when they're confronted by the police. So unless you all have any other questions, I'm just gonna ask that you reverse the lower court, and I'll leave it there.
Any other questions? All right, you'll have some time for rebuttal.
Thank you.
Mr. Scrutenboer.
May it please the court, Jerry Scrotenboer, Ingham County Assistant Prosecutor for Plaintiff Appellee. 3 independent grounds for affirming. The first is that there was no seizure. He never stopped defendant. Defendant was parked in a very strange place in a CVS.
CVS. I said
CVS.
Walgreens. Maybe
Yeah,
it was
CVS. Yeah, CVS parking lot at about 5 a.m. with it raining. The entire encounter with defendant was to deal with him, was to deal with, I don't want you driving away in this horrific car. This thing is in bad shape. It should not be there. And that's
To do with calling the drug dog, though.
a different point. That doesn't have a thing to do with whether or not the person is in custody, has been detained. A police officer may call a drug dog for any time, anything he wants, as long as it doesn't extend a stop. If there is a detention, if there is no detention in the first place, there's no problem.
Let's assume there was a detention. I'm not sure that's your strongest argument.
Yeah.
I mean, they did, he did ask for his identification. He got it. He told him to go over here and talk to my partner. So assuming you lose that it actually was a seizure, where do you go from there?
Oh, obviously the strongest is the next one. There was no extension. You look at the video. The officer is still talking to defendant, who is having trouble answering the questions because of his stroke, is still talking to him to deal with what we should do with you. How far away, how far are you going? Oh, about 10 miles yet. He still is dealing with that situation. The reason for let's assume it was a detention. Now, defendant is complaining about 20 seconds. I think he said 20 or 30 seconds in there. Now, would the police officer have been done with him within the next 20 or 30 seconds? The answer is no. So therefore, there is no extension here. Defendant is, and that is the entire thing about Rodriguez. You cannot extend a stop, and it wasn't extended. Now, defendant is misinterpreting Rodriguez and all the other cases by saying, well, wait a minute, the officer diverted the attention. Well, that's not the point. Rodriguez doesn't say if he diverts or if there's an extension. No, it says if there's an extension, through diverting. So there was no extension here. And then we go on to the third step. Did the officer have reasonable suspicion, which isn't much. Now, yes, nervousness by itself does not show reasonable suspicion. The fact the guy had drugs in the past does not by itself show reasonable suspicion. However, when you add these things together with his constantly reaching into the car, that does give reasonable suspicion. Now, defendant is once again making a mistake in saying, well, this is what the officer said. Oh, wait a minute. What the officer thinks at the time is irrelevant, as long as the court can, based on the objective facts, come up with the proper response. And I'm not making that up. Justice Levin wrote that in a unanimous decision in Arterbury, 1988, cited in my brief. Oh yeah, I forgot to mention, for that very first point of defendant not being detained, defendant cites Freeman. In Freeman, the officer specifically testified, oh yeah, he wasn't free to go. So that is not true here. These are three independent grounds. Yes, the best one is there is no extension. And I ask the court to affirm. Thank you.
Thank you. Counsel, Rebuttal, any questions?
No questions.
Okay. Yeah, I'd like you to address the point Mr. Scrotenbauer made about the Levin opinion and that it's an objective standard as opposed to subjective.
I'll start there.
On the reasonable suspicion.
I'll start there. Arterbury deals with, which is the case that the prosecutor cites,
Right.
deals with the probable cause, whether there's probable cause to arrest. We're dealing with a reasonable suspicion standard here, and there's case law directly on point, dating back to Terry itself, that says we have to look at what the police do. The quote from Terry that I put in my reply brief, it's in footnote 6. I'm sorry, I kind of hid it there. What says that the police officer must be able to point to specific and articulable facts, which taken together with rational inferences from those facts, reasonably warrant the intrusion. The police officer must be able to point to the facts. The Supreme Court in Lo Sierra in the 90s, I don't know if that's Lo Sierra, I don't know if I'm saying it right, I'm sorry. But it's saying that there's a quote that the officer is obliged to articulate how the behavior that he observed suggested in light of his experience and training and inference of criminal activity.
Isn't it the case that that reasonable suspicion must exist whether or not the defendant has been seized? I mean, the ability to search the vehicle, is a separate issue from whether it's a search or seizure. So it seems to me they're independent of one another to some degree. I mean, take my hypothetical involving the DUI, we immediately order someone out of the vehicle to do a breathalyzer. I don't, have they been seized? I suppose maybe so, but I'm not sure. Does it matter?
I don't know the exact state of, and I apologize, I should. I don't know the exact state of whether a drug dog is termed a search if it's just sniffing around a car willy-nilly, right? I don't know precisely where the law stands on there. I think the prosecutor would argue that the police can walk around with a drug dog on cars parked on the street because regardless if there's no seizure. But yeah. I think that's kind of beside the point of this case because there was a seizure here. And so by the time my client was seized, and then the extension occurred, then clearly he was subject to, a Fourth Amendment intrusion. And so if he was seized and an extension occurred, we have a Fourth Amendment issue, which leads me to my other point I wanted to make on rebuttal, which is the prosecutor is right that Rodriguez itself specifically only talks about extensions of stops. But the case law in the decade since Rodriguez says that it also includes things or instances that occur in the middle of an already in progress detention, an already in progress seizure. So that's, the Karst case from the Idaho Supreme Court, the Whitley case, the rule I cited from the Sixth Circuit, all the other cases I cite in my brief talk about mid-seizure extensions of the stop, where an officer is detouring or deviating from the purpose of the initial stop. An officer can't get away with violating the Fourth Amendment by saying, well, you know what, I'm going to do this in the middle instead of at the end. That it wouldn't make sense because that would just allow a runaround around the rule of Rodriguez. So if an officer is detouring or is deviating from the purpose of that initial stop without independent reasonable suspicion, if the officer had walked up to my client's car, this didn't happen obviously, but if the officer had walked up to my client's car and spotted drugs obviously he's allowed to detour from the purpose of the initial stop at that point because he has independent reasonable suspicion of criminal activity. But he didn't have any of that here. And so, the only thing that the people rely on in their brief is the reaching into the car. I think I've explained on my opening argument why that's not sufficient. His drug history alone certainly can't be sufficient. And I think that's all and I think we have the clear, unequivocal testimony from the police officer that he did it only because of his knowledge of my client's history with dangerous drugs. It's clear, unequivocal testimony, and it's supported by the police report he wrote at the time. So I think, given that there is no reasonable suspicion here to support that deviation, I would ask this court to reverse, and I'm happy to answer any more questions.
Any other questions?
No.
Thank you very much. Appreciate your arguments. Well done. That case is submitted. Brings us to item 8, docket number 371403, People of the State of Michigan versus Johnny Lee Tucker. And Ms. Young is arguing via Zoom for 10 minutes. Technology.
Morning, Your Honors.
Good morning. Ms. Young,
Little Kelly Young on behalf of Johnny Tucker.
and we're
And,
granted you 10 minutes of argument time.
okay,
So, you know.
yeah, interestingly, that this is very similar to the case that you just heard about a dog sniff and what happened. And in here, I guess what bothers me the most is that the dog sniffed, alerted in the wrong area of the car. And this is the second case I've had in my career where the dog alerted on the wrong place of the vehicle. And so based on that, the officer pulled the couple out of the car, put them in handcuffs, did not give them Miranda rights. And then because one of the passengers was a female, he had to call other officers to come in. And then he searched the vehicle without consent. And I agree with, prior counsel that was an extended stay. He had the dog was in his vehicle. He didn't have to call and get a dog. He got their license and registration. And by the way, I'm going to search your vehicle. And so he took the dog around twice.
I think you might have skipped a step here because you cut right to the dog alerting, which is sort of the end of the process in a certain way, because you apparently heard the prior argument. What I'm more interested in hearing about is what was the reasonable articulable suspicion of drug activity by these defendants? Can you enlighten me as to what exactly the drug team officers conveyed to Officer Perry about defendants' involvement in drug trafficking?
I think it basically was gossip. I don't think they didn't have any hard evidence. They just
I'm
said,
sorry, I couldn't hear that.
oh, I think it was basically gossip. We think that they're characters that have been known to be in the drug world. Let's keep an eye on them.
Well, I thought it
And
was a little bit more than that, wasn't it? And again, correct me if I'm wrong, but I
okay,
believe from what I have seen in the record that defendant's vehicle stopped for a brief period of time at a known drug house and then proceeded down the roadway where they were then stopped by Officer Perry for a traffic violation. So,
And, yes, I don't recall him stopping.
okay, all right, well, we'll
And
look.
I'm gonna look at that because that, yes, that would change things a bit. But no, that, from my recollection, they're just driving down the road.
Okay, and said to have been involved in drug trafficking.
They were unsavory characters. Let's keep an eye on them.
Okay. All right, go ahead. I'm done.
Okay, and so what I do go into in my brief is that, they're starting to look at the accuracy of the canine dogs and what they can pick up. And even this office, the canine officer in this case said, that they're so sensitive, they can smell a scent as through the breeze that goes by. And, so there's studies that have been done that show that these dogs, that even currency can have enough drugs on it for a dog to alert a complete innocent possession of currency. So I just wanted to bring that up, that I think that this dog, I don't think that the dog's alert justified their arrest.
Okay, any questions for Ms. Young? All right, seeing none. Mr. Morton?
Good morning, may it please the court. Assistant Attorney General Brent Morton on behalf of Menominee County. I just got to make sure that's right.
Right, yeah, since you're not living in Menominee County, presumably.
As far as the two arguments that were made in response, I just would like to say the basis of the canine sniff I discussed in my brief on pages 12 to 13. If you look in the transcript of the first day, the second half of the transcript, pages 58 and 94 indicate, as you did, that Upset had notified the officer that there were two known individuals known to traffic drugs. They had just left a known drug house and were going north on M35 to the location of the stop. So they'd just been at the drug house. It
Right.
wasn't stale information.
Right, yeah, that I knew. Okay, it's the known to traffic drugs piece that I may have overlooked or forgot about in my preparation.
And that I believe that verbiage was a quote from the testimony. But if you go back to
Officer Perry's testimony, he's saying this is what
Yes.
they told me.
Yes, but if you go back to those transcript pages 58 and 94, then you can read exactly what it was.
Okay, yeah.
So we can get that part right.
Sure.
The other response is, as a case of People versus Clark, 220 in Michigan, this is pages 243 and 44. The hit doesn't have to be perfect. I think there's a recognition these canine dogs are smelling scents, and scents can blow around and move around. And so,
As did the drugs in this case, which I think were on one side of the vehicle and then move to the other.
well, and yeah, and that's, I appreciate you stealing my second point is Miss Monroe, when they found the 8-ball, she's like, well, that's not, I didn't see that before there.
Yeah.
So they were moving around. They can be moved around. There's several issues here. I read over my brief the last couple of days in preparation. I think I've covered all the issues, but if I haven't, I'm happy to answer any questions, but otherwise I'll rely on my brief.
Any questions for Mr. Morton? Okay,
Thank you.
thank you. Ms. Young, any rebuttal?
No, any questions?
I don't think so. Very good. Thank you. We appreciate
Thank
your
you.
arguments. And that case is submitted. Mr. Morton, you're with us again for item 9. Docket number 373-375, People of the State of Michigan versus Tiara Miranda Pagel. And Mr. Branch is There he is. We can't hear you. I think you're muted, Mr. Branch.
I am.
There you are.
Okay, let's try again.
Yes.
Okay, William F. Branch, attorney for the defendant appellant in this matter. And this, judges, as you know, is a tale of the nefarious characters who occupy the far reaches of the Upper Peninsula in Wisconsin, particularly two fellows, one named Travis Knipp, Knipp, also known as Benny the Butcher, and Dude. Benny the Butcher is a drug dealer. The police know him be a person who method is to locate vulnerable females, get them addicted to drugs, and then hide behind them, use them to shield his own evil activities. Dude's his supplier, who is actually in Wisconsin. So the question in this matter is strictly, did the trial court err in scoring 50 points instead of 5 for OV 15? The 50 points requires a showing that the drugs were transported across the state lines here from Wisconsin to Michigan. So did the evidence show that Ms. Pagel in fact ever received drugs from Dude in Wisconsin and transported them to Benny the Butcher in the UP? OV15 is a McGraw variable. The scoring is specific to conduct related to the sentencing offense. Now, the prosecutor in their brief says that Ms. Pagel's testimony was less credible than contrary testimony. But our question is, what is the contrary testimony? Nobody ever testified that Ms. Pagel met with or received drugs from Dude or that she transported them across the state lines. The evidence, in fact, was just the contrary. She drove to Dude's house and waited. I think she sent the butcher some text from there, but he wasn't home and she drove on. There's no evidence that she consummated any type of drug transaction with people named Jay and Pat, who were mentioned in phone records. Nothing in the phone records indicate that she ever met with Dude or that she had any drugs when she crossed the state line. Now, everybody in this case was a drug dealer or user. The meth in question could have come from anybody. The trooper Barnett said that he found drugs, paraphernalia, and baggies previously in Jessica Supanik's house. Jessica and Knipp were discussing another drug deal while Miss Paywell was sorting baby clothes in another room. Regarding Miss Pagel's admission that the baggies might show her, well, I think she would probably show her fingerprints. Remember, police found the same type of baggies in Jessica's home. Miss Pagel assumed that Knipp, by that time, she assumed that Knipp had put the drugs in her baggies. Thus, they were in the drugs from the baggies, from her house, which show her prints. Remember also the baggies were not unique and were in fact never fingerprinted. Now, Knipp, Benny the Butcher, was alone in the car for several minutes while Trooper Barnett questioned Miss Pagel. He had easy access to the baby bag. Again, he was known to sacrifice females for his own protection. So the testimony does not support the OV scoring simply because there is no testimony that the drugs were carried across the state lines. There's nothing to be more credible than Miss Pagel's testimony because there was no testimony contradicting it. The error is not harmless. It affects the scoring guidelines. Miss Pagel, for being Benny the Butcher's patsy, is doing 120 months in the Michigan Department of Corrections. So we would ask that the matter be remanded for resentencing with a scoring of 5 points for OV 15. Yes, the current sentence would still fall within corrected guidelines, but hopefully it will result in some reduction of her sentence. Thank you.
Any questions for Mr. Branch? All right. Don't have any now. You will have time for rebuttal.
Good morning again. May it please the court, Assistant Attorney General Brent Morton on behalf of Baraga County. Just briefly, I think Mr. Branch's arguments are a good closing argument. I think that he's arguing that Ms. Pagel's not guilty, but the jury beyond a reasonable doubt found guilt. And the trial court determined that Jessica's testimony about Kip arranging for the defendant to buy the meth and bring it into Michigan, and then texting her directions to give to Tiara to go get the meth in Wisconsin was credible. And the trial court's entitled to that credibility, to the deference when it comes to a credibility assessment. So we ask you to affirm, and I'm happy to answer any questions.
Any questions for Mr. Morton? No, we don't have
Thank
any.
you.
Thank you very much. Mr. Branch, any rebuttal?
Yes, well, first of all, I'm very impressed, and it makes me feel bad that the prosecutor drove all the way down to Lansing. I didn't even drive up from Detroit, so I'm impressed by that. However, no, I'm not arguing.
Roll call here. Mr. Branch,
Yeah.
don't give him too much credit. He walked over here.
Don't give him too.
So.
What did
With the Attorney General's
okay?
office. I can see.
Oh, he's with the Attorney General office. Well, I withdraw my impression then. Now I'm not impressed anymore. I thought he drove down from the UP. Okay. We got that out of the way. That cleared up. No, I'm not arguing that she's not guilty. If I was, that would have been, I would have argued insufficiency of evidence. Remember, she wasn't convicted. She was convicted just of possession, I think, with intent to deliver the drugs. So nothing in that charge requires a showing that she carried him across state lines. So it's two different things. This is strictly a judicial fact-finding thing. And that's why it's important to bear in mind that this is a situation where the standard of review is de novo, because this is strictly a fact finding by the judge that she had those drugs crossing the state lines. The jury was not required to make that finding, so it's two different things. That's all I have.
Right. Thank you very much. Appreciate your arguments. We're always happy to see you, Mr. Branch. Appreciate it. And you as well. Have a safe walk back to the office. It is cold out there. All right.
Yeah, he's right about that. It is cold out. Okay, thank you.
That's quite all right. All right, that case is submitted. All right,
Bye-bye.
that brings us now to our 11 a.m. call, it being a couple minutes till noon. Mr. Feifelski, you've been very patient. Usually our clerk's office, when they see lawyers arguing multiple cases, as you've seen, as you sat back there, trying to argue, schedule them back to back. I don't know why that didn't happen in your case, but I will call item 10, docket number 376234, in re guardianship of DPP.
Good morning again, Your Honors. May it please the court, James Feifelski appearing on behalf of the appellant. And it's a good education to sit and watch how things unfold here. I'll try to keep it very simple. I think the probate court erred because two key reasons under this statute 700-5204 2B, which I believe is clearly the part of the statute the court relied on issuing this guardianship over the objection of the sole custodial parent, who is my client. First of all, that the parent did not permit the minor to reside with another person. And I'll elaborate on that. And then secondly, that the parent did actually provide the other person, the potential guardian, with legal authority for the minor's care and maintenance under a proposed power of attorney. The testimony, I believe, was very clear. And this is a situation that a very difficult, acrimonious divorce. Mother lost custody back in 2022. Father had sole custody. Large family. There were 7 minor children, other adult children. Father is a native of Northern Ireland. And I believe most of the minor children, and I believe the 3 at the time, well, 2 at the time, and now just 1 is still a minor, were born in Ireland, had lived there until mother took them back to Ypsilanti, where she was born and raised, and did not return them, although they were all living together before the divorce in Ireland. As it happens, teenagers sometimes will dig their heels in. And this became a very difficult, challenging saga for my client, the father, who after he received an order of sole custody and sole parenting time, tried to pick up all of these children at a local police station, I think the Washtenaw County Sheriff's Department. And that's when three teenage boys essentially began to attack their father. The guardian, Emma Huntley, her husband was there, and I've got, I think, some of the testimony that my client testified to at the hearing was almost an instigation of these teenagers to turn against their father because of what had happened with his sister losing custody. It's a difficult factual background, but I think the testimony was clear that my client always wanted his remaining child, we'll just focus on the one who's really the subject of the petition at this point, to return to Northern Ireland. And in an effort to do that and try to work cooperatively with his ex-wife's family members, who he didn't have any family in Michigan. She does. She's a big family, siblings. He granted 2 different power of attorneys, the delegation of parental rights to Emma Huntley, and one prior to that to one of the other siblings of his ex-wife. Again, in an effort to try to work with the reality which these teenage boys were resistant to going back to Ireland. And at that time, their mother was still in Ypsilanti. But at the time of the petition, later 2024, by that time, their mother had actually returned to Northern Ireland, I think in September of that, maybe September of 2023, a year before, because there were 4 younger minor children under the care and custody of father, my client. And so now, at the time the petition is filed in the probate court, both parents are in Northern Ireland. There's the one child who is still with the former sister-in-law, essentially against my client's will. And while I understand the probate court was grappling with a challenging situation where a teenager, and I think at the time of the petition he was 15. I may have said 13 in my brief, but he was 15. And despite whatever the family court judge could do in terms of issuing custody order, as we all know, you can't really force a child to get on a plane and ship him over to Ireland. Again, however, my client was trying to do his best to be cooperative with former family members from his ex-wife's family. And then I think the real key is, while he may have granted permission for the child to be with Emma Huntley, the guardian, on past occasions, the testimony is clear, even from Miss Huntley, that at the time when, just before she filed the petition, she asked for another power of attorney.
Wouldn't this entire situation, couldn't it have been avoided had your client just agreed to extend the guardianship and give the durable power of attorney?
Well, he did attempt to, with 2 very simple
With
conditions.
Which the guardian then rejected. So there we are.
Well, I think under the power of attorney statute that allows a parent to delegate certain powers, I don't think it restricts or limits a father's ability to carve out some conditions, which these were minimal conditions. Try to facilitate contact, communication between this child and me as the father.
Which I'm not even sure the guardian was opposed to, honestly. She just wasn't going to, I think reasonably argued, or counsel did, that would create confusion with respect to the effectiveness of the durable power of attorney if these conditions are, and now maybe a court is looking at this at some later time, trying to figure out, well, okay, did you send the kids back to Ireland for a visit? Did you let dad talk to him on the phone before we can, or a medical professional is left wondering that and maybe hesitant to provide care because they're in no position to know whether or not those conditions have been met. So the guardian said, no, that's not going to work.
Well, when so the interesting sort of, and the testimony came from the guardian, that when she asked for a power of attorney and received a response from father or maybe his counsel,
Yep.
that there were these two conditions. She simply said no, or maybe even ignored, just said, I'm going to file the petition for guardianship.
Yeah.
I don't, but then in her testimony, she acknowledges that those two conditions on their own are not unreasonable. To try to facilitate doesn't mean you have to force this child to get on a phone. It just means facilitate.
Wasn't there also testimony by her that one of her main concerns was being able to get medical care for the child, and that she was running into a problem with that because when she presented this, you know, if she presented this guardianship with conditions, the provider wouldn't know whether those conditions had been met or not, or what, so whether she had legal authority to take those steps. Like, that was a big concern for her, correct?
That's correct. She did express that concern. There was no other evidence or statements or testimony from physicians or medical providers. But I think, again, in the context of if a power of attorney otherwise grants somebody the ability to obtain medical care, and there's no limitation on the care and maintenance of the child, there's just these contact conditions, then I don't think it would be necessarily reasonable for a medical provider to prevent the provision of care in a scenario like that. Maybe it would be a question, but I just don't think that was really laid down or corroborated such that it would be unreasonable. The other thing I want to point to, and I think this is the probate court's definition of or permit in the statute, that the first part of the statute, the parent permits the minor to reside with another person. The appellee actually cites a case that I was remiss in noting, but it's the Duchesne versus Saint Germain case that notes that the term permit in the statute is in the present tense. The previous version of the statute did say have permitted. And the case actually goes into talking about how previously have permitted would have been, I think, the past participle. I'm going back to English 101.
Back to grammar school.
Present perfect tense, the present perfect tense. And yet the statute now says, and at the time of this petition says, permit. So did my client, the sole custodial parent, permit the minor child to reside with Miss Huntley at the time of the petition? And that's what Duchesne talks about. It also cites an unpublished opinion of this court, Cato versus Hepworth, that notes the same basic scenario. But what's interesting in the Cato case, which is the unpublished case cited by Duchesne, it's the father's sister who sought guardianship. And the court notes that although the father was requesting the child be returned before the petition was filed, the only reason that Nicole was not residing with respondents at the time the petition was filed because Cato refused to relinquish possession. Under these circumstances, we cannot conclude the statute provided the court with jurisdiction to appoint a guardian. While the appellee wants to argue that the simple presence of the child in her home means that there's permission by the father, I don't think that's the case when the testimony is clear. He's been continually trying to get them to return to Ireland. And at the time, just before the petition, again, restated that while offering a temporary Band-Aid, if you will, still wanted to have this child go back to Ireland with him. Under these circumstances, I think this is much more like the case in Duchesne and in Cato, where there actually is no permission granted by the parent for this child to reside with the petitioner, the guardian, at the time of the petition. Previous permissions, temporary power of attorneys that last up to 6 months, that's not the focus under the present tense of permit which is how the statute is written. And I think, again, while I recognize the difficulty the probate court would have in doing something with a difficult situation, I think there are other ways than kind of glossing over the plain language of the statute, which has this present tense verb of permit. And I think it's clear, the evidence is that my client did not permit this child to continue to reside with his former sister-in-law. And there are reasons he gives for that. One of which was she was a witness in a previous criminal case that ended up in acquittal, or she was listed as a witness along with her husband in a previous criminal case that was brought by her ex-wife. These were terrible circumstances, but ultimately, my client ended up being the sole custodial father, which has to continue to carry some merit or weight. And that's why I think there's also a valid constitutional argument when it comes to his ability to choose what happens with his child. And I think it's clear again that I believe that the probate court misinterpreted the statute, read it too broadly, and under these circumstances, I don't think there's evidence that the father gave permission for the client to reside there. So I would ask the court to reverse the probate court, and hopefully they can find other ways to sort out this mess. Thank you very much.
Any other questions? All right. Thank you, Mr.
Thank you very
Pafelski.
much.
Well done.
Yeah,
Appreciate
thank you.
your arguments here today. That case is submitted. Okay, item 11, docket number 375538, In re JM. And Attorney Kelly is arguing via Zoom. And her opposing counsel
Have they checked in?
does not appear to be present. So we'll wait for Ms. Kelly, who represents the respondent appellant.
Good afternoon, Your Honor. Melissa Calais representing JM. Are you ready for me to proceed? The audio cuts out just briefly when I get brought in.
Please do.
Thank you. I would like to touch on two issues, which are thoroughly briefed, but I want to touch on a few issues relating to them. First is regarding the lack of understanding of the need for treatment. For JM to be considered a person requiring treatment, she needs to lack an understanding of the need for treatment based on the specific statutory ground under subsection C that the court determined she fell under the mental health code. I would just ask the court to consider the ramifications of what would happen if the court permits the trial court's ruling to stand in this particular case. The court record was very clear in certain respects, specifically that my client wanted to try some verbal therapies such as CBT, DBT. She also expressed some interest in natural remedies. And she wanted to give those a try before she jumped into taking a pretty heavy duty antipsychotic medication. And additionally, I think that there was some mischaracterization in the doctor's testimony that JM was unwilling to engage in any kind of treatment when the record very clearly shows that was simply not the case. She was voluntarily taking medications, including lithium. There was some dispute about the dosage of those medications, and there was some dispute about whether or not they should add on an antipsychotic medication. And it's important to note that the trial court record very clearly reflects that the doctor testified that he did not actually believe that JM was psychotic, but nevertheless was recommending an antipsychotic medication be added to her medications. So to me, the record's very clear that she didn't lack an understanding of the need for treatment. She simply disagreed about how to go about this. And she wanted to take a much more cautious, conservative approach to treatment, which I think is appropriate.
Well, she sought out treatment in the first instance, did she not?
That is correct. And I think that that also ties both to this point as well as the second point of any risk of harm and kind of this idea that she just, willy-nilly moved across the country at a whim and had no plan and these kind of speculative ideas that really aren't based in anything in the record. She was moving across country, but the record is clear that she affirmatively sought out what resources were available here in Michigan. She specifically sought out contact information about the Washtenaw County mental health program. And when she did run into an issue, she specifically called CMH based on that information that she had. They provided her some assistance. She still felt she needed a little bit more help. So she then went to the ER, not so much for the mental health issues precisely, but those mental health issues were being exacerbated by a lack of sleep. I know I fairly recently had a trip myself where my return flight got canceled and I got stranded overnight in an airport. And I think we've all had those experiences, and it's not fun. And you definitely get kind of, cranky and lack of sleep, and you're not eating great. And I don't think any of us are at our best under those circumstances. And what did JM do when she found herself in those circumstances? She reached out for help based on the information she had sought out. And then by calling CMH. She also went to the ER to try to get some medication for the lack of sleep, because she had enough awareness to know that her lack of sleep, which resulted from missing her flight and being up all night at an airport, was exacerbating her mental health issues. So she thought if she can get some sleep, the mental health issues are going to kind of go back to her norm, which is something that, didn't require hospitalization before this episode. So I think that it's important to be aware of those circumstances. And if the court affirms in this particular case, really what we're saying is that when someone, first of all, someone could be penalized for reaching out for help, which I don't think is a dynamic that is appropriate to set up. Secondly, that somebody can be penalized for asking, even simply inquiring whether or not there are options available that are maybe not as extreme as taking a powerful antipsychotic medication. And additionally, if somebody, even questions dosages, she was taking lithium, which is, viewed as a pretty standard mood stabilizer, not something that most people would consider a lack of compliance if they're, taking a medication like that the doctor required, but she wanted to start it at a lower dose and kind of see how that went. So from my perspective in reviewing the record, I believe that on this particular record, I don't believe it's appropriate to say that there was clear and convincing evidence that JM lacked the understanding for the need for treatment. And if the court does determine that this is appropriate grounds for that, I think that there are a lot of really negative collateral consequences that could happen to the public at large as a result of that. Along those lines, the prosecutor points out in their brief that the doctor testified, I think the exact quote was that she's not being open with us regarding her plans about, why she moved to Michigan, what her living arrangement was going to be. I would posit that I don't think she has to be particularly open with them. She went to the ER to try to get sleep medication. She gets moved over to a psych hospital. So now she's being questioned by a psychiatrist who she doesn't have a prior relationship with, is not the provider that she sought out. And if she doesn't answer his questions that in her mind have really nothing to do with her mental health, he's asking about her living arrangements and her spiritual practices and beliefs. I think she should be free to decline answering those types of questions, and that the fact that she is not answering those questions does not establish the prosecutor's duty to show clear and convincing evidence of risk of harm. Because otherwise, that basically means anytime anybody seeks out treatment, there's essentially no right to privacy whatsoever. Somebody has to answer any questions about anything whatsoever that a doctor is asking. Otherwise, they're going to be accused of not being open, and therefore there's this lack of understanding of the need of treatment.
Ms. Kelly, I think we understand your argument quite well. Do you have anything else you feel the need to tell us in conclusion?
In conclusion, I would just very briefly touch on the risk of harm. One thing that I would just like to point out for the court is that the trial court hand wrote into the order inadvertent risk of harm. I think that just goes to show how even in the trial court's mind, this kind of barely was rising to the level where the court felt it was appropriate to enter the order. And in terms of there being some sort of risk that she might be taking advantage of others, I think that frankly would really be more appropriate for a guardianship than a mental health order. Does the court have any other questions for me?
Questions? All right. We don't, and you are unopposed. So thank you very much for your argument today. Thanks for appearing, and the case is submitted.
Thank you.
Thank you. All right, that now brings us out of order to item 6. Mr. Scrutenboer, you've been very patient. That is docket number 371-632. People of the State of Michigan versus Mauricio Antonio Pinchera. And Attorney Nunley is appearing via Zoom.
Good afternoon, Your Honor. Royce Nunley appearing on behalf of the appellant. I did not hear what the court may or may not have said prior. Should I proceed with my argument?
Please do.
Thank you. Okay, so this case, it's a bit of an unusual CSE case in my opinion, simply because there were so many witnesses that appeared on behalf of the accused. In a nutshell, my client was convicted of allegedly touching his very young daughter as she co-slept between her mom and dad by putting his hand up her shirt and rubbing her chest. You know, facts that generally I think in these cases you see don't really get much sympathy from family members. However, in this case, it kind of struck me that Mr. Pinchera had his wife came to testify on his behalf, his other daughter, who was 2 or 3 years older than the alleged victim, the maternal grandmother came in to testify, and then they had a lot of family and friends who knew the family intimately, who showed up to testify on his behalf. So it immediately struck me as a case that, you know, is a little bit unusual in that sense. The two arguments that we advance is that there wasn't enough evidence, a sufficiency of the evidence argument, and also that the prosecutor committed prosecutorial misconduct during her closing argument. So I think like a big issue in the case was the alleged victim kept a diary when she was young. And there was a pretrial motion about the diary and being able to use it for whatever purpose. And when they got to trial, the alleged victim was asked if she remembered how old she was when the incident happened. She didn't. So the prosecutor then attempted to use a diary to refresh her recollection just on a date. And they were allowed to do so. She looked at the diary, and it refreshed her recollection that at the time that she wrote the entry, she was, I think, 11 years old. It was in September. And she was asked if she could tell, like, if she knew how long before the diary entry that the incident had allegedly occurred, to which she answered no, she couldn't. But the contents of the diary and the statement in the diary were never presented. There was no testimony whatsoever about the actual contents. It was just used for, you know, to refresh her memory of the date.
And you're not claiming error with respect to how the prosecutor used the diary to refresh the complainant's recollection, correct? That was
No.
properly.
Yeah, no.
The argument revolves around the subsequent references to the diary by the prosecutor, correct?
Correct. Yeah. Like there's no argument that she shouldn't have been allowed to use the diary for the date. It's just the contents. And you know, this was hot on everybody's mind because like I said, there's a pretrial motion about it. The court heard it, made its decision. And even when the prosecutor was questioning the witness, when she began to refresh her recollection, before she even really got into it, I think the defense counsel jumped up and objected to hearsay before the prosecutor even had a chance to really ask her a question that would elicit hearsay, which the judge recognized. So this was a pretty important issue. And when the prosecutor got to her closing argument, and I quoted it verbatim in my brief, there were 4 instances where she mentioned the contents of the diary, where she basically said 4 different times to the jury that the alleged victim had written in the diary about, you know, what had happened, about her dad, like touching her in the bed, that her dad, she even says, quote unquote, rubbed her boobs at one point. And unfortunately, there wasn't a defense objection. I think that there
That was the victim's testimony about the rubbing of the body parts. So
yeah.
I don't see what that has to do with the diary unless the prosecutor said, well, it's in the diary that she wrote, he rubbed
Yeah.
my body part.
Yeah, and that's
So which is
essentially what
it?
it was.
Which is it? It's my question to you.
I'm sorry, say that one more time. I
Which is
apologize.
it? Which of those two things occurred in the closing argument?
Oh, what occurred is the prosecutor said in so many words that she wrote in her diary that
Well, in
his
so
dad
many
had done
words,
this.
or
Yeah, no, I mean,
yeah,
I
in your
have,
brief. So just
sure. So
yeah.
the first thing that was said, and this is all verbatim, and I said, is there something, an entry in your diary that would be dated that would help you determine how old you were at the time that this incident occurred?
Okay, we're
Because
past that though. Now we're into the closing argument.
yeah, this is a
Okay.
closing argument.
All right.
Right, that would have talked about the incident you dated, and she said yes. And I refreshed her memory with the dated entry. I asked her to read it, and I said, does that content of that dated entry where you discussed this incident in the bed help you remember what date it was a dated entry? Then she goes on to say, the evidence shows that she first wrote about this incident that occurred in the bed in a diary entry from September of 2017 when she was 11. There is no testimony at all that she wrote about this incident in a diary.
Well, what else would the jury have inferred from the questioning that refreshed her recollection other than that she had written in the diary about the
Well,
incident?
yeah, no, of course that they would infer that. And I think that's why everybody was fighting about it before trial. Because, you know, of course, the prosecution would want to show that because a jury would infer that, okay, well, if the date of whatever she's looking at refreshes her memory to the incident, then whatever, right? And then the defense would want to keep it out for that purpose. And that's fine. I just believe that the prosecutor crossed the line, you know, mentioning like the last one I think is the most where she crossed the line, where she says there is literally no evidence that 11 years old or before 11 years old, when she wrote the diary entry in September of 2017, that she was so mentally ill and that she misunderstood her boobs being rubbed by her dad. Now, I believe that trying to argue this in her closing on 4 separate occasions, the contents of the diary, where defense counsel didn't have any chance, you know, if they wanted to introduce those statements into evidence, then they could have tried, right? They could have done that, and then defense counsel would have been able to cross-examine the witness about the statements. I don't believe that they would have been able to lay a proper foundation for it just from the one question that the prosecutor asked, if she could tell by looking at the entry how long prior to writing the entry did the alleged incident occur, and she just answered with the one word, which said no. So I think that it was extremely like harmful as well, kind of by when the jury was deliberating, they asked at one point, they sent out a question to the judge asking if they could see the contents of the diary,
Right.
which shows you that, you know, it was on their mind and that they thought that there was something in there that would have helped them with their decision. So I think that she went beyond what was permissible. I don't think speaking about the contents inside of the diary, if it's merely used to refresh somebody's recollection about a date, and that's what they're using for, and that's what the court allowed it for that purpose, then I think the only thing that the prosecutor can reasonably argue is the date that that the alleged victim testified that, you know, by September 17th or September 2017, the incident had occurred.
Mhm.
Right.
Right.
And, you know, the prosecutor who argued in his brief that either way, like the diary could have been admissible. It could have been admissible under MRE 801. You know, he makes his argument there. I don't believe that that's a good argument for a couple of reasons. First is I don't think they'd be able to lay a foundation as I mentioned. And second, I don't think it's a good argument because it just didn't happen. That's not what we're talking about, right? It wasn't
In other words,
introduced
you're
into
saying it was
evidence.
not admitted into evidence.
Right.
The fact that
No,
it
but
could have been is kind of irrelevant at this
right,
point. That what you're
right. The prosecutor didn't move to admit it into evidence, so the judge didn't have to make a ruling. Like I said, they argued about it pre-trial, so that's not what we're talking about.
Yeah.
So I mean, I tried to be thorough in my brief. My statement of facts is a lot longer than than I usually write them, but reading the transcripts, I think all of us have probably read enough transcripts that you may agree with me that sometimes it's a little dry and it doesn't necessarily blow your hair back. I think that this case read a little differently for me. Reading it, I thought it was very compelling, and I think it's hard not to just feel something for the whole situation, for everybody involved. So I tried to put that in the brief because I think it really does come through. So I'm happy to entertain questions, obviously. If not, then I would turn it over to brother counsel, who I'd like to thank for graciously stipulating to me moving this call to a little later. I had a conflict. I'd like to thank the court as well for that. It really saved my hide.
Great. We were glad to accommodate you. Any other questions for Mr. Nunley? No, not, you'll have time for rebuttal.
Thank you.
Scrotenborg, you can give us your appearance, and then I want to ask you about the diary.
Oh, yeah, that's what I plan on talking about.
Okay.
May it please the court, Jerry Scrotenborg, Ingham County Assistant Prosecutor for Plaintiff Appellee. Not a single thing that defendant complains about now has been preserved for appeal. It is all plain error standard. Now,
You'd agree the diary was not admitted into evidence.
that's correct.
So it's not part of the record. And yet I went back and I checked Mr. Nunley. He's right. There were 4 separate references by the prosecutor in the argument to the effect that she wrote in the diary about this incident. And so, I mean, that's arguing a fact not in evidence because the diary hasn't been admitted. It was used solely to refresh her recollection so that we could date the incident and her age at the time of the incident.
That the diary itself was not admitted as evidence doesn't mean that the diary is not part of the record. The diary was mentioned quite a bit. We start with, actually, would looking at the diary help you date when this happened?
That wasn't what was then argued. Here are a few of the statements made by the prosecutor. Does the content of that dated entry, where you discussed this incident in the bed, help you remember?
Yes.
Okay. Hang on. Since at least September of 2017, when she first discussed in her diary that this incident in the bed happened. I'll stop there. So prosecutor's now testifying as to what was written in the diary.
The prosecutor is referring to various things. And let's not forget, not a single objection to any of it.
I get all that. Yeah, that's fine.
And the point about plain error is that it's supposed to be rare, and also no instruction could have prevented the prejudice. And this is not that situation at all. The judge could very easily, yes, this judge who was referred to earlier this morning as being a very, very good judge, could very easily say to the prosecutor, sorry, you're going outside the record. You are not to do this. Jury, you are to completely ignore this evidence. The prosecutor is doing something thoroughly improper. And if you don't, we'll have to declare a mistrial. I am quoting from a California Supreme Court decision, People versus Bolton, which came out in 1979 when it suggested such an instruction. If that instruction could not have taken care of it, well, then we have a new trial. But that instruction would have. And there was no objection at any time, despite this being an excellent trial lawyer also, who was on this point. Defendant is not entitled to a new trial. By the way, defendant is misanalyzing my point about this could have come in. What I'm saying, I'm not saying that, well, I'm sorry, what I'm saying is defendant hasn't shown the real prejudice he needs to show for plain error, because this would have been admitted anyway as a statement, as a prior consistent statement, given what the defense was, which is that her mental illness has done all this stuff. Oh, wait a minute. She made the statement long, long ago. So therefore, defendant hasn't shown quite the manifest injustice that he needs to show for plain error review. And therefore, I'm asking the court to affirm.
Any questions for Mr. Scruton? Okay, Mr. Nunley, any rebuttal?
Yeah, briefly, I understand the plain error standard, and it's a tough burden to meet. But I do believe that this error, I believe it was plain, and I do believe that it seriously affected the fairness of the trial. It was such an issue, this diary, that they had a pretrial motion over it. They duked it out. The judge, listened to the arguments and made a ruling. And following that judge's ruling, nobody even tried to introduce the diary into evidence. They didn't. And quoting from this diary, or referring to the contents of the diary on 4 separate occasions, and then seeing that the jury asked the court if they could see the diary afterwards, I think that shows that the jury took it serious, and I believe that is something that seriously affects the fairness of this trial. Now, the diary, brother counsel argued that the diary was part of the record. The contents clearly were not part of the record. Right. So the argument that he goes back to, that it would have been admitted, it wasn't. The defendant didn't have an opportunity. If the prosecution wanted to admit it, a defendant was given no opportunity to even voir dire on the contents of the diary. And from what little we know, one thing we do know is that the alleged victim did say that she wasn't able to tell from looking at the entry how far prior to the entry that this allegedly happened. So I think there's foundational problems. But if I take any questions that you have, if not, I'd rest on my brief.
Okay, I don't think we have any other questions for you. We appreciate your arguments. Thank you for appearing today, and the case is submitted. That brings us to our last item of the day. It's item 12, docket number 374679. Ray I.B. Gilmore minor will be submitted on the briefs, and with that, we'll be in recess until 10 o'clock tomorrow morning.